Good afternoon and welcome to this week's Business in 2022 webinar presentation. My name is Kathy Purdy and I'm a marketing manager here at Bond. Just two quick housekeeping items to go over before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows throughout the program. Once today's webinar has ended, we would appreciate you taking a moment to complete the brief survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. So to get us started today, it's my pleasure to introduce today's moderator, Adam Mastroleo.
Thank you, Kathy, and Happy New Year to everyone who is joining us. We appreciate your continued attendance at our Tuesday webinars. We have a packed program for you today. There is a lot going on that we want to talk about. And first, we're going to lead off with Tom Simcoe. Tom is a member in our Albany office. He focuses on taxation and finance, and he is going to cover a new law that will be taking effect shortly regarding the whistleblower protections that are afforded under the New York State labor law. So Tom, welcome. Please take it away.
Thanks very much, Adam, and Happy New Year to everybody. So I'm here to talk about amendments to labor law section 740, that section entitled Retaliatory Personnel Action by Employer, Prohibition. This is the whistleblower protection statute under New York law. So we have some major changes going into effect on January 26th with respect to that law, including who is protected by the law, the kinds of laws that whistleblowing about are covered under the statute by its protections. What is considered retaliatory conduct has been expanded, and the consequences of violating the statute have also been expanded notably. So the relevance of this is particularly acute for nonprofit organizations who have been adopting policies over the last decade or so, first in response to a nudge and then in response to a shove, which we'll talk about in a little bit of detail. But it's also relevant for all employers because it applies to every organization, company, business that has one employee or more. So if you're not listening from a nonprofit organization, this is all still relevant to you. You can probably fall asleep for the next 3 slides or so, but then you should kind of check right back in as everything that's discussed will apply to your company as well. So Kathy, if you can advance the slide. So by way of background, nonprofit organizations began adopting whistleblower policies about 13, 14 years ago in response to changes that were implemented in the IRS's Form 990 information return. Those changes were implemented as part of a sort of federal government-wide response to the Enron governance debacle and Sarbanes-Oxley. So it required organizations to disclose whether or not they had whistleblower policies, and that was the first time that most nonprofit organizations thought about whether they should have one at all. There was very little guidance from the IRS about what a whistleblower policy should do, other than that it should protect individuals who report wrongdoing, but there were no particular consequence for not having one, other than that your donors and other stakeholders that could see your tax returns would be aware that you didn't have one. If you could advance, Kathy. So that was the nudge from the IRS to get a whistleblower policy. Then came the shove from New York State. So in 2013, with the Nonprofit Revitalization Act, the legislature passed Not-for-Profit Corporation Law, Section 715B, which applies to employees who have 20 or more employees and $1 million plus in revenue. So if you met those two requirements, if you were, let's say, a mid-sized to large nonprofit, you're required to have a whistleblower policy. And 715B added some meat to the bones as to what a whistleblower policy should look like, describing certain things that had to be there or the policy must. So per the statute, the policy has to protect directors, officers, key persons, employees, or volunteers of the organizations. It had to protect when reports were made in good faith. If you could advance, Kathy. It had to protect, back one, where there were actions that were illegal, that were reported by the whistleblower, actions that were illegal, fraudulent, or in violation of any adopted policy of the corporation. So it wasn't strictly focused on legality. The violations of adopted policy were also protected. So you might have a conflict of interest policy or gift acceptance policy or another policy that is critical to good governance and functioning of a nonprofit. So you had to protect when someone reported about a violation of those policies. And also, so then it was protecting employees from intimidation, harassment, discrimination, or other retaliation or adverse employment consequence for someone reporting something in violation of the whistleblower policy. So the statute also provided a requirement for distribution, had to be distributed to all directors, officers, key persons, employees, and volunteers providing substantial services to the corporation. Fortunately, the statute provided that all you had to do to meet this distribution requirement was to post it on your website. So this solved the logistical problem of how do we make sure everybody gets a copy and also document that we've made sure everybody gets a copy. So that was an easy way to deal with that problem. If you could go forward. There were also certain procedural requirements included in 715B of the not-for-profit corporation law. You had to have a designated compliance officer. You had to exclude employees from certain board-level decision-making about the policy and its administration. So the lawyers who advise clients that are not-for-profits drafted policies that would meet all these specific requirements that exist in the statute. Also, so one, providing a policy that would meet the statutory requirements, and two, providing a roadmap for nonprofit employers for what to do exactly when you get a complaint that looks like a whistleblower claim of some sort, or someone blowing a whistle, I should say, which isn't always crystal clear, but it would provide you a way to respond to things that look like whistleblowing in a way that would keep you compliant with the law. So want to give you a policy that if you follow the policy, you're complying with the law. We'd note that there's no specific provisions in the statute itself saying what would happen if you violated it or failed to have a policy, but courts have found there's an implied cause of action for employees by virtue of the intent of the legislature to protect employees. So if you could advance, Kathy. So alongside this activity of whistleblower policies being adopted in response to the IRS and New York State legislature requirements, there was and still is labor law section 740, which provided some narrow whistleblower protection under New York law, whether or not you had a policy at all. So it would protect employees who reported violations of law by their employers, which create substantial and specific danger to public health or safety, or which constitute healthcare fraud. So just these two types of whistleblower complaints would trigger the protection of the statute. And as you can imagine, most of the time, if an employee is reporting something like a violation of tax law or financial irregularity, it wouldn't hit either a violation of public health or safety or a healthcare fraud type area, which would trigger the protection of the statute. That the existing statute included a requirement that the employee had to go to the employer first before taking the claim outside the employer in order to be protected by the statute. There was an affirmative defense that the person who made the report was an independent contractor rather than an employee, and another affirmative defense that the employee was fired for reasons or had adverse employment action taken against him or her for reasons other than the whistleblowing. And the statute provides some remedies for the employee, an injunction against the employer's conduct, which had been complained about, reinstatement to the position, or rehired where an employee was improperly terminated, could be provided with lost wages, and there was a $10,000 civil penalty. If you could advance, Kathy. So that brings us to where we are today. So policies were drafted with Form 990 and MPCL Section 715B compliance in mind. Because this is the nonprofit sector we're talking about, we drafted these policies very broadly, not just to apply when there were complaints related to illegality or fraud, but also ethical standard breaches and other things that are consistent with the high ethical standards of the nonprofit sector, and also expectations of transparency that are organic throughout the nonprofit sector in order to cultivate strong relationships with donors and the public, et cetera. If you could move ahead, Kathy. So into that realm, we have new labor law section 740, which now has new musts that don't align perfectly with the existing and still applicable musts of the not-for-profit corporation law. So, and this is where we get into what applies to everybody and not just nonprofits. So first is the near universal applicability. So for nonprofits, you no longer can rely on the fact that you have fewer than 20 employees or less than $1 million in revenue. You should be thinking about this law and the protections that it applies to all employees, because it will apply to the review of any action taken if you receive something that resembles a whistleblower complaint. The new law also expands who is protected. So most notably, it now covers former employees and independent contractors. So these are categories which you don't necessarily see under the not-for-profit corporation law, section 715B. And so existing policies may not include reference to former employees in them. And so it would be advisable to consider amending employees to include them. The law also expands the reporting subject matter that's covered. And this in particular is an area where existing policies may be insufficient. So the new law specifically refers to violations of federal, state, or local statute, ordinances, or executive orders. And the form of whistleblower policy that I typically have provided to clients has included reference to executive orders, but it does not include references to ordinances. Likewise, a violation of a judicial or administrative decision, ruling, or order, a report about such a violation will be covered by the whistleblower protection statute. I have not seen any whistleblower policies that reference judicial administration, decision, rulings, or orders, not the type of thing that typically was contemplated in the drafting of those policies. So that's another area to take a look at and see whether a policy needs to be expanded if you have one. If you could advance, Kathy. I mentioned the capacity standard of the not-for-profit corporation law. So as noted, 715B of the NPCL requires protection where an employee has made a report in good faith. So that seems to be sort of a subjective standard. You're looking at what the person intended when they made the report. Section 740 focuses on protection provided to an employee that reasonably believes there's been a violation. So that seems to be more of an objective standard, focusing on what it was that the employee thought was a violation and whether or not that was reasonable. These two standards are not necessarily overlapping in every case. So, I think there should be some nuanced thinking around how policies acknowledge the protections that need to be provided for employees along these standards. You couldn't simply choose one or the other and be assured that you're going to be appropriately treating all potential whistleblower claims. Another important point is that the definition of what constitutes prohibited retaliation has been expanded by the statute. Most notably, there's reference to adverse action, including reporting or contacting U.S. immigration authorities regarding an employee's immigration status or the immigration status of other members of an employee's household. I personally never contemplated that reporting an employee that might be in violation of the immigration laws might be considered retaliation against an employee, certainly under prior law. So this is something which definitely was not reflected in my policies, and I would be surprised if anyone had it reflected in their policies anywhere. And it's not even clear whether this is even consistent with the immigration laws. Certainly not my expertise, but I'm wondering whether maybe an immigration lawyer, I don't know if any on the call can advise us, but whether you have an affirmative duty to report something related to an employee's immigration status, if you're aware of it, I don't know. But anyway, that's something which should be mentioned in policies, as well as actions that impact former or future employment. So that directly ties into folks that, the protection that's now provided to former employees and specific to them and the types of retaliation that they might potentially experience. Kathy, if you could move ahead. Another important change, just from a practical perspective, is that Labor Law Section 40 requires employers to post information about the law, the protections provided by the law, conspicuously in an easily accessible and well-lighted place, customarily frequented by employees and applicants for employment. So this is very different from what we're dealing with under the NPCL. Again, that one you could simply post something on your website. Now it appears that you have to physically place a copy of information about Labor Law Section 740. My thought on that is to actually include the entire text of that statute in the notice to make sure that a summary isn't somehow deemed to be insufficient, but it has to be in some place not only frequented by employees, but also applicants for employment, which certainly leaves me scratching my head as to exactly where that's supposed to be. And particularly since applicants are expressly not protected under the statute, it's not clear why it needs to be someplace where they can see it. Anyway, but that's what the new law is requiring. Other notable change, again, punitive damages. So the consequences to employers for violating the law are now more significant because it's not just the economic damages experienced by the employee, but also the possibility of punitive damages, which could be applied against an employer for willful, malicious, or wanton conduct. And of course, it's hard to imagine where if a court found that there was a retaliatory action taken by an employer, it's hard to imagine that they might not find that that was willfully, maliciously, or wantonly taken. So something definitely for employers to be aware of. The stakes for having a good whistleblower policy that checks the boxes required by the statute are the potential consequences for failing to do that have expanded by virtue of the statute. One other item to note, as under the prior law, there was a requirement that an employee go to the employer first with a complaint. That's no longer always required in every circumstance. The statute indicates that you do need to go to the employer first to have the protection of the statute, but then provides some exceptions which could easily swallow the rule, which are beyond the scope of this discussion. Kathy, if you could advance. So the big takeaways for nonprofit clients, the policies that have been drafted specifically to comply with NPCL Section 715B will no longer ensure compliance with the requirements of Labor Law Section 740. And I think, again, since those policies are partly to show that you have the required policy, but also perhaps even more importantly, intended to give you a roadmap for what to do if you get something that looks like a whistleblower policy to keep yourselves out of trouble. I think that everyone should consider revisiting and revising those policies, particularly smaller organizations that didn't need one at all now have to consider whether they should have one. I think most cases, if you've got more than one or two employees, really, it would be advisable to have them, particularly if you receive funding from grant-making institutions and governmental entities and those that will be looking to see that you're following all the good governance requirements. Again, not out of my area of expertise, but for-profit organizations and other employers all should also be considering adopting these policies because the stakes of a foot fault here have increased dramatically with the introduction of punitive damages. I think that's all I've got for you. Adam, I'll kick it back over to you.
Tom, thanks so much. There's a lot of information there. So please, if you have questions, reach out. Next, we are going to turn it over to Lisa Feldman. Lisa is an attorney in our New York City office. Lisa is going to talk to us about some New York City employment laws.
Thank you, Adam. Good afternoon, everyone. As Adam mentioned, I've been tracking 2 New York City bills, one of which became law over the holidays, and one of which, as of this morning, is still on the mayor's desk for signature. So I'll walk you through both of those. The first is COVID-19 child vaccination time, which went into effect on December 24th and notably has retroactive application dating back to November 2nd, which is the date that the Pfizer vaccine was approved for ages 5 to 11. This new leave provides 4 hours of leave per injection per child, and it can be used for either taking a child to a vaccine or for caring for a child during temporary side effects from the vaccine. It amends the New York City Earned Safe Sick Leave Act, and I just want to note here that it provides additional time that your employees are entitled to, and it covers all New York City private employers. However, if you have less than 5 employees and less than 1 million net income, the leave would be unpaid. Next slide, please. And the law defines child and parents. A child is someone under the age of 18 or an older child incapable of self-care due to mental or physical disability. A parent is inclusive of biological, foster, step, adoptive, legal guardian, someone acting in loco parentis or who acted in loco parentis. Next slide. What may an employer request of an employee under this leave? So first, an employer may request reasonable notice that the leave will be used. However, there's a slightly different standard based on whether or not the need to use this leave will be foreseeable. So if the need is foreseeable, for example, if I make an appointment for my daughter to get a vaccine in 4 days from now, the reasonable advance notice may be requested not to exceed 7 days out from when I would be using the leave as an employee. However, if the need to use this leave is not foreseeable, for example, if my daughter already had the vaccine but woke up this morning with a fever and I need to call in, then an employer can request notice as soon as practicable. In addition, an employer may request reasonable documentation within 7 days that provides proof that this child for whom the leave was taken was vaccinated against COVID-19. And I'll note here that the law also includes a provision that states that employers may impose disciplinary action if the leave is misused. Next slide, please. Okay, so that's what an employer can do. What can an employer not do? An employer may not ask the employee to make up the missed time. An employer may not ask an employee to find a replacement worker for the time. And I want to note here that this does not seem to be a prohibition about replacing the employee for their shift. It's just you can't ask the employee to find their own replacement. An employer may not count this leave against other earned safe sick leave, and an employer may not retaliate for taking this time. Next slide. So again, as I mentioned, there is retroactive application and there are penalties imposed, which I'll get into momentarily. It's retroactively applied to November 2nd, as I mentioned. And the key piece here is that if leave was taken between November 2nd until the law went into effect on the 24th of December, that employee needs to be compensated in the pay period following the law's enactment. So for any employer who pays on a biweekly basis, this would be the payroll period to start coming into compliance. Otherwise, the employee must be paid in the next payroll cycle following when they use the leave. Okay, so I'll explain the penalties momentarily. I just want to start on a slightly happier note that there is a 60-day phase-in period, during which employers must receive written notice of a violation and 15 days to cure before any of these penalties can be imposed. And calculating 60 days out from December 24th, this would end after February 22nd. Next slide, please. So these are the penalties. If leave was taken but not compensated, an employer must pay greater of $250 or 3 times the wages the employee would have earned. If leave was denied, please go back. If leave was denied or charged against the paid safe sick time, it's $500 penalty. Both of the above are charged for each instance. And on a per employee basis, there's additional civil penalties. First violation up to and inclusive of $500. Second violation within 2 years of a first is up to and inclusive of $750. Additional violations up to and inclusive of $1,000. Next slide, please. And just a quick note on collective bargaining agreements. The impact here is similar to the Safe Sick Leave Act generally. Unless the same conditions in the Safe Sick Leave Act are met, this provision cannot be waived. And I also want to note that if your CBA offers a more generous COVID-19 child vaccination time, this does not relieve an employer from compliance with those terms. Next slide. The law does expire December 31st, 2022, the end of this year. However, this expiration does not excuse an employer from not paying any time that's been accrued on or before that date. Next slide. And that's the COVID-19 child vaccination leave in a nutshell. The next bill is a New York City salary transparency bill. The City Council passed this on December 15th, 2021. As of this morning, it is currently on the mayor's desk for signature, and it becomes effective 120 days after becoming law. So just a quick refresher on the New York City legislative process. A bill can become a law in 2 different ways. The mayor can sign it into law within 30 days, or the mayor can choose not to sign it and not to veto it, in which case it would come back to the council and automatically become law. So we're basically looking at anywhere between now and January 14th, within the next 10 days, we'll know whether or not it's becoming law, and it will go into effect 120 days after that. So this new bill would require posting minimum and maximum salaries on job listings. It amends the New York City human rights law and applies to employers of 4 or more, dating back from the 12 months before the start of an alleged unlawful discriminatory practice through the end of that practice. And independent contractors and family members of the employer, if employed by the employer, are included in this count. And this covers employment agencies, employers, employees, and their agents. So to what type of job listings does this apply? Great question. Advertisement is not defined for us. We do know it is inclusive of jobs, promotions, and transfers. We do know it applies to jobs located within New York City. I did notice that the words listings and posting were also both used. So I think there's likely a very broad application. And we do know it does not include a job advertisement for temporary employment at a temporary help firm. Next slide. And one final note on this is that what degree of employer certainty is required? What does it turn on? Because this will be included, if it becomes law, it will be included as an unlawful discriminatory practice under the New York City Human Rights Law. So it would turn on the employer's good faith belief at the time of the posting that this is the salary range the employer would pay for this opportunity. Okay, thank you very much. If you have any questions, they'll be posting my email at the end of the seminar.
Lisa, thank you so much. That was a lot of information and we really appreciate it. I know some of you have asked if the presentation is going to be available with the slides. It will. You should receive a follow-up email in the next couple of days or so. And that's going to be important because there are a number of active links in my presentation, which I'll be doing a little bit later. And I'm going to be addressing some of the COVID issues that you all are raising in the chat, so please hang tight. Next up, we have Teresa Rusnick, who has presented on this webinar several times regarding New York's paid sick leave law. And she is here to give us an update on what is going on with that law and the regulations related to that law. So Teresa, please take it away.
All right, thanks, Adam, and good afternoon, everyone. As Adam said, I'm going to be talking about New York State paid sick leave updates. Please distinguish this in your minds from COVID-19 based leave. Certainly, employees can use paid sick leave for COVID-19 reasons, but this is not in and of itself a COVID-19 leave mandate. Adam's going to be talking about those. This is actually one that we haven't heard about in a little while from the state. And this has to do with finalized regulations on paid sick leave that New York finally put out on December 22nd, 2021. The initial proposed paid sick leave regulations came out on December 9th. So it took them over a year to go from proposed regulations to final regulations. And in that time, they didn't make any changes. So the final regulations are identical to the proposed regulations. So you're probably wondering, why is she presenting about this? I'm presenting about it because in addition to telling us that the finalized regulations are identical to the proposed ones, the Department of Labor also included 27 comments, which were received from members of the public, and then their responses to the comments, some of which are helpful to illuminate some of the longstanding issues that we've had with paid sick leave, and I'll get into those in a minute. So that's what I'm going to be talking about, just so we all remember. Paid sick leave is the leave that you all started to have to give around January 1st of last year. You can either front load the leave, or the leave can accrue at a rate of 1 hour for every 30 hours worked. It applies to all employees in the state of New York. And like I said, you had to start giving it to people on January 1st. Total amount of leave depends on the size and to a certain extent the income level of the employer, with most employees under 100 employees having to give 40 hours of paid sick leave every year, and those with over 100 employees having to give at least 56 hours of paid sick leave every year. So that's the leave mandate that I'm talking about. Kathy, next slide, please. So some of the things that DOL told us by way of the comment and response period are helpful to at least answer some of the questions that I know I've been getting since paid sick leave became a leave mandate that we had to be concerned with. So one of the questions I got frequently is, how do we know if we have over 100 or under 100 employees for purposes of whether we give 40 hours of leave or 56 hours of leave? And DOL had never previously said you have to count all of your people in New York State and outside of New York State, or you just have to count all your people in New York State. This was evidently one of the comments that they got on the proposed regulations, and they have said in response, employers are to determine the number of employees by counting the highest total number employed concurrently nationwide at any point during the year. So you count your employees in New York, you count your employees outside of New York, you count your part-time employees, your temporary employees, anyone that you give a W-2 to, and you take the highest total number employed concurrently nationwide at any point during the year. And that's how you determine if you're over 100 or under 100 for purposes of how much paid sick leave you're going to have to give people. So that was a good clarification. I thought that came out of the comments. A less helpful, in fact, very unhelpful clarification, but nevertheless a clarification that came out of the notice and comment period was this issue of whether when employers front load the total amount of leave, they still have to allow employees to carry over all unused leave from year to year. The reason that this is interesting and important as a question is because employers are allowed to cap the total use of leave per year to 40 or 56 hours. But historically, New York DOL had always said, even though you can cap use, you still have to allow carryover, which makes no sense because then employees have large banks of leave and they can't use all of it. They can only use 40 or 56 hours or whatever number that you cap it at north of those two limits. And so the question that DOL was asked is one that I've been asked a lot, which is, can we cap carryover? If we're capping use, in particular, can we cap carryover if we front load the 56 hours or the 40 hours every January 1st or on the employee's anniversary or on any 12-month period? And DOL said no. DOL said no, you cannot cap the total amount of leave carried over, even when that leave is front loaded yearly. So I'm sorry. I know this isn't the answer many of us wanted. It doesn't make sense to me that this continues to be the way that DOL approaches this. It is not consistent with what other states have done with their paid sick leave mandates. I can tell you that. But this at least is a clarification. You cannot cap carryover leave, even when the leave is front loaded every year. And then finally for this slide, one thing that DOL did say is employers may elect to give employees the option to be paid out for the leave at year end instead of carrying it over. So please understand, you can't require that. You can't say you're going to be paid out for all leave at the end of the year and can't carry it over, but you can give people the option to either carry it over or get paid out. There is some question about whether or not that's consistent with New York City's paid sick leave mandates. I think you can read it that it isn't. I also think you can read some of the guidance that's come out of New York City to say that any inconsistencies between the New York City law on this point and the New York State law on this point are supposed to be resolved in favor of the New York State law interpretation because they want those two leaves to be consistent. But if you find yourself in that position, please do reach out to counsel because there is at least the potential for some conflict between the two laws there. Next slide, Kathy. Okay. Couple other things we learned from the comments. So employers may not mandate that an employee use paid sick leave for a covered reason at the exclusion of all other available and applicable paid leave. This is another question I got a lot. Okay, so the easiest way to do this one is by example. If an employer has a PTO and PSL policy and someone goes out for PSL covered reason and they want to use PTO, the question that I was getting is, can we require them to use PSL? Because it's a PSL covered reason, that's why we have PSL. The answer that DOL is giving us here is no. If they're otherwise allowed to use PTO for this reason and they want to use PTO instead of PSL, they can use their PTO here. You cannot require them to use PSL. I think an open question there is, what if the person does not have other available paid leave? What if they want to go out for PSL covered reason and all they have is unpaid leave available and they'd rather take unpaid leave than use their PSL? I'm not sure that the DOL's answers in response to the comments went as far as telling us what we should do about that particular situation. Another thing DOL said had to do with notice requirements. Employers may not impose a different notice requirement when leave is foreseeable than when it is not. If you recall, under paid family leave and some other leave mandates that we have at the federal and state levels, you can require 30 days of notice when leave is foreseeable. DOL declined to allow employers to impose that kind of limitation, citing disagreements about when something is truly foreseeable or not. So you may not do that. DOL is going to develop and make available a sample attestation form that employers may use as documentation from employees to verify the need for paid sick leave. One of the things that you know about paid sick leave documentation is that you can only ask for documentation if someone's been out for 3 shifts or more. You can't ask for less than that, and the type of documentation that you can ask for is very limited. It has to do with verifying that the person is out for a paid sick leave covered reason, not getting any confidential medical information. And one of the ways you can do that is to not even get medical documentation, but to get an attestation form from an employee saying that they're using their paid sick leave time for a reason consistent with paid sick leave law. We had seen an attestation form available from DOL up to this point. It's still not there. I checked the website this morning. Certainly we'll let you know when that comes out. I know previous to this announcement, I had developed some sample attestation forms for employers to use when they wanted to go that documentation route with their employees. Next slide, please. Okay, and so this I think is probably the most complicated thing that happened as a result of the, well, not happened as a result of the comments, but didn't get clarified by the comments or the responses from DOL. And this takes a little explaining. So generally speaking, you can either front load paid sick leave or you can accrue it. So you can either front load the 40 or 56 hours at the beginning of the year, the beginning of any 12-month period, or employees can accrue it. And if they accrue it, they must receive at least 1 hour of paid sick leave for every 30 hours worked. That's set by the statute. So that's at least the accrual rate that you have to have. And that's the accrual rate that we thought was applicable until we saw the proposed regulations from last year. So the proposed regulations, which again came out in December of 2020, so really 2 calendar years ago now, raised the issue of rounding paid sick leave accruals for the first time. And so those proposed regulations, which are now final, so this language is not just proposed anymore, this is finalized regulation, instructed employers that when calculating accruals for time worked in increments less than 30 hours, employers may round accrued leave to the nearest 5 minutes, the nearest 1/10 or 1/4 of an hour, provided that it will not result over a period of time in a failure to provide the proper accrual of leave to employees for all the time that they've actually worked. So for the first time that I was aware of, DOL looked at this paid sick leave issue back in December of 2020 and said, rounding. You're going to have to round when people work less than 30 hours in some specified time period. And what I told employers back then is, there's not a whole lot you can do with this at this moment. They haven't told us what time period we need to use. They haven't really explained, what increments you can go to. There's not a whole lot we can do with this at this moment. Just make sure you keep providing 1 hour for every 30 hours worked, and we'll see what DOL does in the finalized regulations. So next slide, please. So unfortunately, we know that in the finalized regulations, DOL kept this. They did not change this rounding language, and the questions that we had back in December are largely still here. Not the least of which is how often employers should reconcile PSL banks to determine the actual amount of leave available to employees. Remember, under paid sick leave law, you have an obligation to tell your employees whenever they ask you how much paid sick leave they have available. You also have an obligation to set for your employees what increments of time they can use paid sick leave in, whether that's an hour, 2 hours, 15 minutes. It's up to the employer as long as the increments are not longer than 4-hour blocks. So all of those things are going to come into play when we're talking about rounding paid sick leave. And none of those questions are particularly easy to answer when it comes to rounding. So the department, unfortunately, did little in the way of aiding employers. They merely affirmed that incremental leave is required and that employers could round the time if they desired. They did not tell us what increments of time are to be used. They did not really tell us which or excuse me, how often you need to reconcile those PSL banks. Is it every pay period? Is it every week? Is it every day? They didn't really tell us. So please reach out to council if you still have questions on that. We can walk through some of the risks and benefits of taking different approaches to this question with you. For now, I'm going to leave it at that because I know we're running close on time, and turn it over to Adam.
Teresa, thank you so much. Again, a ton of incredibly helpful information. I will say this, the question section exploded during Teresa's presentation, as it usually does when we're talking about paid sick leave.
Leave mandates will do that.
Yeah. So I would encourage you all, if you have a question, to work with Teresa or whomever you work with at Bond regarding these issues, because this guidance and the positions the Department of Labor are taking may be confusing to you, and you may need some further assistance. So please feel free to reach out. In any event, thank you, Teresa. Really appreciate your time. Okay, now moving on. I thought it would be helpful. January, what are we, 4th today? COVID, where are we now in two very specific areas? So first, let's talk about where are we in terms of numbers. According to the Department of Health, here is where we are. The picture does not look great at the moment. So as of January 3rd, we had 66,000 approximately new cases in New York. That's a 291% increase over the 14-day within 14 days. 39,000 of these cases are in New York City. Here in Onondaga County, where I am, 842 new cases. These are records, at least here in Onondaga County, for new cases. We continue to smash daily case records. The hospitalization numbers are also going up significantly. You see there, we have currently 7,774 hospitalized in New York State. That's an increase of 73% within the last 14 days. And I just put a note, our prior peak was in April of 2020, where we had 13,000 hospitalized approximately. 91 deaths, again, an increase of 50%. These numbers are to be expected with the explosion of new cases. Now, hopefully the Omicron variant is less severe and we're going to see fewer hospitalizations and deaths per new case, but that remains to be seen because those are lagging statistics. All right, next slide, please. Now, I want to look at two different things that I think a lot of clients or a lot of our clients are still dealing with. So first of all, what are the current quarantine requirements and recommendations? I saw a lot of questions about this in the Q&A section, so let's hit it right off the bat. First of all, what does New York say? New York says that when you have a close contact, if you're the response differs between if you're fully vaccinated or not. So if you are fully vaccinated or you have recovered from previously diagnosed laboratory confirmed COVID-19, you do not need to quarantine following an exposure. However, you should be tested between days 3 and 5 after your exposure and wear a mask in public settings. If you are not fully vaccinated or not recovered from COVID in the past 3 months, there's a 10-day quarantine that is going to be required, and testing is not required to end the quarantine if you don't have symptoms. Now, I mentioned that I have put some links in this presentation. This is an example of one. The link at the bottom of the page takes you to Onondaga County's flow chart. So Onondaga County did a very nice thing, and they put a flow chart together for you to analyze what to do if you're exposed. And the flow chart depends on whether you're fully vaccinated or not. It's a great resource, so I'd encourage you all to look at that. Next slide, please. Now, what we just talked about was New York's guidance as it relates to a close contact. Now I'm going to talk about what is New York's guidance as it relates to a positive test. So generally, 10 days of isolation from symptom onset or positive test if asymptomatic is going to be required with a positive test. Now, I will qualify that because on December 24th, the Department of Health put out guidance that shortened that 10-day quarantine or isolation period in very limited circumstances. So I'll talk about that guidance first of all. The link to the guidance is right in the PowerPoint presentation. So This guidance document, like I said, shortens the isolation requirement to 5 days, but only in very limited circumstances. So one, it's only for healthcare workers or workers in the critical workforce. It only applies to fully vaccinated individuals. It only applies to those who are asymptomatic, or if they have mild symptoms, there are certain recovery metrics that you utilize. The individual must consistently wear a well-fitting mask, a higher level mask such as a KN95 or a fit-tested N95 respirator while at work. And I will point out that the regular cloth masks that you see are not sufficient under this guidance. This guidance does not apply to individuals who are moderately to severely immunocompromised. And those individuals who are allowed to return to work after 5 days have to continue to stay home and observe other elements of isolation for the full 10-day period. So let me clarify very quickly in case I didn't say this. This guidance only applies to returning to work. It doesn't get you out of the full isolation period, but it does allow you to return to work only after 5 days. Next slide, please. Workers participating in this reduced timeline program should be instructed that they should practice social distancing from coworkers at all times unless they have to be present around other coworkers. If they have to remove their mask for things such as eating or drinking, they should separate themselves from others. Next slide, please. Now, there's a couple of issues that have arisen for clients with this new guidance. First of all, you have to make sure that if you're going to try to bring people back after 5 days, do you qualify either in the healthcare as a healthcare employer or as critical workforce? The guidance document that I linked lists out specifically who would be included within that definition. Now, unfortunately, this guidance also requires employers to validate symptoms because either someone is asymptomatic or they were mildly symptomatic, but they've improved. So you're going to have to ask questions about that, which is not something I think you want to do. But that's what the Department of Health guidance says. You're going to have to ensure that mask wearing is correct. I put in here conflict with local DOH because it depends on whether your local Department of Health might not be up to speed, so to speak, and may still be requiring a 10-day quarantine. So you might have an employee who has a document from a local health department that says they're quarantined for 10 days. So what do? You have this DOH guidance that says they can come back to work. It's a bit of a conflict. So you're going to want to check with legal counsel if that situation arises. Now, I put potential liability in here. I don't think it's a significant concern, but you're going to be bringing people back earlier than they otherwise would have been under existing guidance up to this point. So is there a concern about a spread or an outbreak if you're going to bring somebody back early? Next slide. I saw several questions in the chat about CDC guidance. As everybody probably knows, the CDC came out with revised guidance in late December that reduced the quarantine period in general for people who test positive to 5 days. New York has not adopted this outside of that limited December 24th guidance document I just talked about. So New York in general has not adopted the 5-day quarantine recommendation that the CDC put out yet. Who knows what New York's going to do, but for now they have not done that. The CDC also has recommendations as it relates to exposure. What I would say with respect to the CDC is it's great that they are recommending these things, but here in New York, we need to follow New York State's guidance rather than the CDC's recommendations. Next slide. Okay, so that brings us up to speed on quarantine requirements following a positive test or exposure. I also want to talk briefly about paid leave. So if you all remember, we've talked about this many times on the webinar, but I want to just give us a snapshot of where we are right now. As many of you know, the FFCRA leave is no longer available. That's the federal paid COVID statute. That expired on September 30th of 2021, so that's gone. What is remaining, however, is New York's paid COVID leave law. And this is the COVID leave law that requires employers to provide up to 14 days of paid leave, depending on size. It is for public and private employers. and it is tied to a mandatory order of quarantine issued by a local health department or any governmental entity authorized to issue that order. It provides job protected leave, can't be charged against other leave, etc. Okay, next slide. Now, I want to clarify or make sure that I discuss the Department of Labor's interpretation of this New York COVID paid leave law, which is found in this January 2021 guidance document, which is linked here. This guidance document states that the New York paid COVID leave is available up to 3 times, so 3 separate periods. However, it states that the second and third time have to be the result of a positive test. So the first COVID leave that someone is entitled to that's based on a quarantine order could be as a result of exposure. The second and third time cannot, according to this guidance document. The guidance document also goes a little bit further and says that if an employer mandates that an employee stays home due to a potential exposure or an exposure, the employer has to keep paying the employee even without a quarantine order. So this goes beyond the text of the statute and goes beyond what the law says you have to do. So whether or not you're going to implement this recommendation or guidance document that was issued by the New York State Department of Labor, that's something you should talk to your attorney about to consider the risks and potential costs. Next slide. All right, so I just want to finally talk about some current issues as it relates to paid leave. So as I mentioned, New York State's COVID paid leave law is tied to a quarantine order. What we're seeing now is local health departments that are overwhelmed and can't keep up with issuing quarantine orders. So your employee might say, I'm going to get a quarantine order, but they don't have it. So some local departments of health, like Onondaga County here in Syracuse, have decided they're going to use self-attestation forms, and I've linked to them here. These self-attestation forms allow employees to fill a document out by themselves. And according to the form, this is sufficient to satisfy the quarantine order requirement. I think, again, you need to talk to your lawyer about whether or not you're going to accept these self-attestation forms before you provide the New York State COVID leave. It's an issue that many of us are going to be running into across the state. Every local health department is going to take a different approach. So make sure you're consulting with your attorney before you make a decision, I'm going to pay the COVID leave or I'm not going to pay the COVID leave. Next slide, please. All right, finally, the last area of paid leave that's available is New York paid family leave. This is available when an employee must care for a dependent under a quarantine order. There are some other qualifying rules. Remember, this is an insurance policy that you have, and New York State has provided a request for COVID-19 quarantine PFL, which I've linked to here, that you can provide to your employees in the event that they need to try to use it. So that is where we are. I'm so sorry that we went over in time, but I thought that it was relevant information that was important to get to you today. Here's the contact information for everyone who presented today. Please feel free to reach out. Thank you all for attending. We look forward to a great year, and we'll see you again next Tuesday.